Good afternoon, good morning, good evening, not legal advice. Please like if you so choose, and I appreciate it. Subscribe, share, let others participate. And hopefully, this has some value, even though it's not legal advice, obviously. But hopefully, it serves to provide entertainment value and discuss legal issues on the side. So, today, I'm going to discuss a little bit about my current status with GTII and their management pre 10K, a little touch on Alpine, and a little touch on my MMTLP arbitration, and a note on class actions. Before I start with that, just a quickie, a few couple of comments about dogs. Why do dogs like conjunctions? Because they like butts. Why do you need a license for a dog and not a cat? Obviously, cats can't drive. What do you call a newborn dog who's very quiet? A hush puppy. And last but not least, who said, I better not eat that? No dog ever. Anyway, wanted to discuss GTII, and I hope you really enjoyed all those wonderful jokes. GTII. So, GTII is a company, obviously, and I think I've mentioned before, I've been in contact with them. I'm concerned about them not having engaged in a transaction, and I'm concerned about the actions of management. So, I've started a, a bunch of conversations with them. We've come up to today, basically. They indicated multiple times to wait for the 10K. The 10K would come out by March 31st, which is Sunday. So I'm expecting that anytime. Could come out today, could come out while I'm making this video. But it's been promised as such, and that the 10K will address the ongoing nature of the company's attempts to consummate a transaction, which they acknowledge would be for the benefit of shareholders, that they would benefit. So I've had numerous communications with the attorney for GTII, Mr. Fattel, and and he stopped responding to them, by the way. So maybe I've been super diligent and he doesn't want to respond, maybe because he can't or chooses not to, or a combination of both. I certainly don't take it personally. Um, but what I did is my last communication, which was Tuesday night, so yesterday, well, no, 2 days ago, which he did not respond to, by the way, but it doesn't make a difference. And I again followed up, and I'm just kind of summarizing. I asked for the insurance information of GTI and its officers and directors. I asked specifically for policy information. I indicated I'd heard information about issues with regard to how management conducted the business. I asked about, I reiterated that the 10K was promised at latest Sunday, and I look forward to reading that. I also indicated, and specifically, and this is kind of the bottom line, and I'm reading from my email, as I indicated, if the 10K turns out to be a sham, litigation will ensue. And I'll get to that at the end of this. So I basically asked for insurance information. I asked for access to the company's books and records. I reaffirmed that the 10K would come out before the 31st, based upon what they have reiterated. 10K would address the issue of the ongoing transaction. I indicated that if it was a sham, that litigation would ensue. And that's basically a summary of that. Now, how do I know that litigation will ensue if the 10K I deem is a sham? Because I'll sue them, and I've indicated as such. So the way it goes from this point in time, just to be upfront, since I've told them exactly what I was going to do, I indicated to wait till the 10K comes out. if they in 10K demonstrate that they're making substantial progress, real progress, to consummating a transaction for the benefit of GTII and its shareholders, then I will not pursue litigation. If, however, after I look at the 10K and thereafter determine it's a sham, I will. And that means that next week there'll be an action filed. I don't know which day specifically, but my intention is that a lawsuit would be filed against at least senior management here in California by next week. And again, the way I see it is either management is not capable of consummating a transaction amongst other problems, and if they need to be replaced, and so be it, and that means everybody in management and the board. Alternatively, if they actually are able to consummate a transaction, as they have suggested, or at least implied, then that's a great alternative also. So one or the other, and if it requires litigation, then I would think that that would suggest that they weren't able to consummate a deal, a new board and executives need to be put in. And I feel comfortable enough speaking to enough people that have transactions in the works to believe that if a new board and new management was involved, that a transaction would get done. That's just my impression. Not a legal opinion, but just that's my impression from dealing with people. And I've spoken to many people who have an interest in various ways in GTII. So it's not just my opinion, it is the opinion of many people. So that's where we're leaving it is. So as of tonight, no response to my March 26th email to Mr. Fattel. Today, it's 2 days later. I expect the 10K anytime. It'll be reviewed in detail. And again, if I'm not satisfied, and I'm really skeptical going in, just to be honest. But if I'm not satisfied, then I will pursue litigation. And my guess is I wouldn't be only one. And I think litigation in this case, I believe, will generate a positive result for shareholders. That's just the way I see it. So that's up to speed. I kind of laid it out to you. Look forward to see the 10K. Like I said, I agreed to wait till the 10K came out. That's where we are. So that's GTII. Alpine, quickly on Alpine. So Alpine's part of GTII, and to the extent it's a prime broker, and people think that if the prime broker goes down, that might encourage a short squeeze. So Alpine's been involved in numerous disciplinary proceedings, 2 ongoing matters, one in Utah, where they, before the NSCC and DTCC, disciplinary proceedings apparently began on March 18th. I say apparently because it's confidential, and we probably won't know until the results come out, but it's basically to kick them out of the system. So that is going forward. I don't think it'll end well with Alpine. Well, I know it's not going to end well, obviously, with Alpine. But in the short term, I don't think this proceeding is going to end well. They have other avenues to appeal, but again, spending millions of dollars on nothing, curiously. But that's ongoing. So that would be to expel Alpine from the NSCC and DTCC. And alternatively, in DC on appeal is the Alpine matter where they sued Finra, and there's an issue or attempt by Alpine to block Finra's attempt to expel them in an expedited fashion. There were briefs filed about a week ago as to a particular code section that the court wanted examined, where the SEC could exempt somebody from the requirement of being a member of Finra. Court wanted both sides briefed. It seemed like to me that was a question by the court to give them grounds for ruling against Alpine, just my impression. And Alpine was quickly opposed to even the question. So that's why I deemed that so. There'll be another brief filed, I think, next Monday. And then after that, the court will have all briefs and they'll issue a ruling, I expect, hopefully within 30 days of that. And that will be on the appeal, Alpine's appeal of the denial of the injunction of the expedited proceeding to kick them out for being scumbags. That's the summary of that. All right, so that's Alpine, and that's up to date in terms of the disciplinary hearing and the briefs, which are going to be filed Monday and which were filed last week. And last but not least is my MMTLP arbitration. So if you've been following this adventure, you know I have displeasure with the arbiters. I've tried to get them disqualified, tried to get discovery, etc. It's been, I would call it a joke to this point in time, but hopefully illustrating how the arbitration system is inept and broken. So, based upon the arbiter's denial, and again, there's three arbiters, but only one rules on everything up until the final hearing. So, this one arbiter, who's also an attorney and he's 80 or 81 years old, um, he doesn't hold hearings and doesn't give reasons for his decisions. And he's ruled against me, I think, on everything. Everything. And the last thing, I think, being when I was asking for discovery relating to Fidelity's 11/15/2022 letter that says they can't sell MMTLP shares, and they failed to produce that document. So I had requested other documents they hadn't produced. Court denied that. The arbiter denied that. Again, no hearing, no ruling. So I've contested the objectivity of this particular arbiter, and if he's not biased, then I've questioned his competency. There's only one or the other. And so what I just filed a couple of days ago, and I'm waiting for a result from the director, although director of arbitration seems to be in the tank too, to be honest. But this was a reply to Finra's opposition. So that's the attorneys for Finra, who are spending literally hundreds of thousands of dollars in defense of this ridiculous action. And it's my request to the director that the arbitration proceeding be suspended and that the competency, legally and intellectually, and or impartiality of the improperly selected deciding arbitration panel members be ascertained. And I ask for a hearing before the director of FINRA arbitration. So that's been outstanding. I think I said a couple days. It's probably more like 5 days that has been filed. There have been a whole series of paperwork based upon the conduct of the arbiters. I've asked numerous times to get them excluded, removed, or to be compliant. So, when I file anything, I'm asking for a hearing and I'm asking for rationale. At this point in time, it's almost like childish refusing to provide that information. So that's pending. When I get a result on that, depending on that, I will be filing a new lawsuit against FINRA. Depending on what the ruling is of the director, but if it's consistent with whatever, I'm going to file a lawsuit against FINRA for a claim that I'm not obligated to pay for anything based upon the fact it's a sham arbitration. The director has another opportunity to cure whatever deficiencies exist, but based upon his action, then I will be suing FINRA, not seeking anything, but seeking to avoid the obligation to pay any monies for this sham proceeding. And we will, and I haven't decided whether I have to go back to federal court or I can file it in state court. I haven't thought about it enough, but that's coming, and that'll be coming before the scheduled arbitration date. And we'll see what happens. And again, I know they're watching this because they've indicated they watch the videos. So I'm just telling you that's what's coming. You'll get to deal with it. I'm giving the director an opportunity to work on it at the current time, but that's it. And last but not least, I know that there's all kinds of class action notices that are going out on MMTLP. It should be, well, it's no surprise to me that they're out hunting. Everybody should make their own independent decision. I'm not a big fan of class actions. I think they're basically not that it doesn't serve a role. And again, like I said, especially like in environmental matters where there's really a health risk and it might serve some purpose like that. But usually in terms of monetary issues, it doesn't come close to compensating people in a reasonable fashion. Now sometimes it may be the only remedy. So I understand when that happens, but shouldn't be the preferred remedy. So not a big fan, but I understand its value. But I have no particular interest. And I know that in the one settlement that occurred in the MMAT, MMTLP matter, or one prospective settlement, that it would be the return was 1.5 cents per share. And so if you had 10,000 shares, that's $150, I think. Not a great return, just my 2 cents. But again, I understand its value, and everybody should do what they think is comfortable. And again, at some point in time, class action, if it's the only remedy, that might make a lot of sense in my view. But if your return is so small, then waiting to pursue class action, there's really no downside to wait. In my mind, that's just my view, not legal advice. My 2 cents. So I will keep you apprised of the arbitration, and as soon as I file my new lawsuit against Finra, hello Finra out there, I will let you know where it is, what it says, and where it's going, and we'll keep track of the arbitration, which to this point in time has been an absolute sham. And I've not disclosed the name of this particular arbiter. I've been nice and kind to this point in time. But at some point in time, if it just continues as such, because, for example, as soon as I file the lawsuit, I'll have to reference his name in the lawsuit. But I'm certainly going to give a recommendation to anybody who might be involved in arbitration and wants to, because I'm going to list the name at some point, but I will give you my critique of this particular arbiter so you can avoid or choose if you so be it. Anyway, so we talked about status of GTI, 10K, and what I've been promised and my concerns, Alpine, the disciplinary proceeding and the briefing almost done, and then a ruling. We talked about MMTLP, my arbitration, where it is, my latest filing 2 days ago or 3 days ago, to ask the director basically to check the competency of the arbiter, and that when that is done, based upon the ruling, I'll be filing a new action against Finra to be free of any obligation, financial obligation for this sham monstrosity. Anyway, to all you out there, be well, take care. Hope this was helpful. If you have comments, questions, please put them in there. I do look at every comment, even though I may not like them all, but I look at them and I'll try to indicate that I've seen it. You will hopefully see that. And if you have questions, please ask. And if I can answer it and provide some kind of coherent response, which is not always possible by me, I will do so. Anyway, be well, take care. I'll keep you apprised after this, and have a great day to everybody out there. And